Welcome to The Point of View. This is your favorite current affairs show here on Channel 1 Television. On The Point of View, we pick the right topics, get the right guests, and ask them relevant questions on issues that matter to you. Big day in the courts of Ghana, the Supreme Court, and also for Ghana's democracy. Two massive judgments. The Supreme Court has ruled by a 5-2 majority decision that the delegate system that chooses presidential and parliamentary candidates for our political parties is unconstitutional. That means that all the major political parties in Ghana have to allow all their members to choose the presidential candidate and also parliamentary candidates per constituency. How big is this judgment and what does it mean for the way our elections are run? We'll be discussing that on the show tonight. There's also, of course, the OSP matter. The constitutionality of the OSP has been grounded in law, but there's a caveat. When we come back, we'll walk through the key judgment and also speak to some key guests. Stay with us.
Big game today as Ghana faces England.
You forgot the eggs.
And the whole nation is ready. Shot on target. Oh, what a save! Benjamin Asari, flying for Ghana.
Politics is always safe.
Every day, in the moments we love, we rely on clean and safe water that flows from Polytank.
Do you want a healthy smile?
Good morning, Raquel. Fresh brew coffee for you.
Oh, thank you, Dr. Maya.
Oh, you're welcome.
But, coffee, tea, red wine, those things cause so much stain on our teeth. But I like to tell my patients that cosmetic whitening is a great, safe, effective way to brighten your teeth, like 4 to 6 shades lighter. So it's important to come in to get an assessment on your teeth to make sure you're a good candidate for whitening, because we want to make sure you have a good foundation.
Yes, I definitely agree. Like you said, and it could be done right here at Bethel Dental.
Also like to make sure patients realize you need to get your whitening done by a licensed dentist or a dental hygienist. So that way you can make sure you're getting the correct product, it's safe, you don't get any burning on your gums, you don't get any sensitivity with your teeth. So those things are super important when you're looking for a place to whiten.
Yes, so why wait? Schedule your appointment today.
Healthy smile.
So, what were the key issues being looked at in the case of the constitutionality of the current electoral system? So, let's run through a few of the key points before we do our interviews. So, I think the core legal question that the plaintiffs were asking for was whether a political party has a right to restrict their internal elections to a select few, the so-called delegates electoral college system. Or does the Constitution guarantee one man, one vote? And for many years, we've had delegates. It was very limited. In fact, if you look at the MPP's 2007 presidential primaries, less than 1,000 people voted in that. Of course, the parties have been expanding this. NDC also expanded it for the 2016 election. And I think they also had some things to say about this. Now, the delegates are described as gatekeepers. So typically, they will involve constituency executives, 275 constituency executives or whichever constituencies there are, national executives, regional executives, and then electoral area coordinators. In the presidential elections for some of the parties now, they include what is called either the ward executives, branch executives, or the polling station executives. Be that as it may, the members of a political party who are not these delegates, so they are not elected, they do not get the chance to vote, right? So this is how the system has been for a long time. 3 senior citizens, Professor Kwabena Frimpong Boateng, he incidentally, a couple of days ago, gave the Atta Mills Memorial Lecture on the 14th anniversary of Professor Mills's death. founder of the Cardiothoracic Center, globally celebrated neurosurgeon. Dr. Nyawonya Otamaklo, founding member of MPP, but a critic of some of the party's actions. Dr. Christina Makunyama, who's a former minister of a number of portfolios, including the environment portfolio, member of NDC Council of Elders. So you see that these three cannot be said to belong to one block, right? Frimpong Boateng is an MPP person. He ran for MPP flag bearership. He was minister for lands and MPP, although he fell out in a way with the MPP. So you can say one NDC and then two half MPP, if that makes sense, right? They were represented by Oliver Baka Vomawo. We know Oliver, founder of Fix the Country, or the main proponent there, Democracy Hub, one of their key legal minds. Done some very interesting work with the Constitutional Review Committee. We've interviewed him on this show a few times. Really, really interesting guy, testing critical laws. And Oliver deserves his onions for this. So Oliver, of course, represented these three to petition the Supreme Court to declare the delegate system unconstitutional and to mandate one member, one vote. All right. So this is what, and they had about 7 reliefs. I don't have the time to go through all, but let me read like a couple of them. They wanted the court to declare that upon a true and proper interpretation of the preamble of Article 1, and 2, as well as Article 33.5, 35.6, D, 42, 55.5 of the Constitution, the election of political parties, presidential and parliamentary candidates constitutes a core element of the party's internal organization within the meaning of Article 55 of the Constitution. Really, 4, that a declaration that the delegates-based electoral college system established under Article 13 of the Constitution of the first defendant being NDC. So they took the parties one by one. So they took the electoral college system that the NDC, the MPP, and the CPP have, and they said those electoral college laws are unconstitutional, now void and of no effect. And then key point, or the relief 8, a consequential order striking down and declaring as unconstitutional the regulations found to be creating these electoral colleges, and then basically to order the political parties to include all registered members. All right. So that was what the 3 were looking for. And as I said, NDC, MPP, CPP, EC, AG as defendants. Now, so the Electoral Commission, of course, they organized elections. They were sued, and they were also enjoined to implement or ensure that the order, if the Supreme Court does give it, is adhered to. As I said, these are the key articles involved: 17 and 42, 35.5. These are the key articles which the suit sort of hang on, right? About 5 key ones. Article 1, that the Constitution is supreme, and then democracy must be made realizable for all citizens, must be made participatory, and now we are all equal before the law. That's what Article 17 and 42 say. And then key point, Article 55.5, political parties must conform to democratic principles in their internal elections. So even though political parties will tell you that we are internal, we are voluntary organizations, the core requirement is that their actions, which is why a lot of times when people feel mistreated in primaries and they go to court, they use Article 55, that it was undemocratic for me to be disqualified, or I was disqualified unfairly. So Article 55 is a very important one that they added. Okay. Now, the main issue here is the AG's decision, right? AG was part of the 5 defendants, and the AG decided to support the plaintiffs. And we know also that the NDC did not oppose. Indeed, the CPP, we heard in subsequent interviews, also sort of supported. So it looks like MPP, even though MPP was one of the 5 defendants, MPP was on his own on this matter. But it appears that the AG's filed submissions formally supporting the plaintiffs, arguing that expanding voting rights within political parties would definitively strengthen Ghana's democratic status, gave it a bit of weight. Because, of course, in the OSP case, the AG agreed again with the plaintiffs, but they thought the OSP did not have the power or did not have the power that it thought it had. So AG's behavior has been interesting. In this matter, they supported the opening up of the system. But in the OSP matter, the AG was against the constitutionality of the OSP. Be that as it may, this is seen as an unexpected pivot, which made and this looks like MPP was on his own here. All right. We didn't expressly hear what the NDC said, but now that the judgment is out, we will know what they think. Now, there was a 7-member panel chaired by His Lordship, the Chief Justice himself, Justice Paul Bafoboni. So this is a very serious constitutional matter. And I need to say that only yesterday, the Supreme Court at 150 celebration was held, and we put a documentary together which discussed the seminal role of the Supreme Court in building our democracy. Right? Whether a president could sack a judge, or whether a president could determine the tenure of a Supreme Court judge. Seminal cases, State versus Amakutu versus Attorney General. All those cases showed the Supreme Court's importance, even in opening up our electoral system, transparent ballot boxes, the whole issue of 31st December as a national holiday. So it's quite interesting that the day after the celebration of Supreme Court at 150, the Supreme Court sits in all its glory and makes a very consequential decision delivered by the Chief Justice himself. This seems to be an eloquent sort of testimony of the Supreme Court's importance in our democracy. And for those who've been watching the space asking for opening up, definitely have to commend the Chief Justice for this, that he chaired the panel and delivered what will be considered a very far-reaching judgment on how our political parties run their elections. So kudos to the CJ there. It was a 5-2 majority decision. There were 2 dissenting. But 5-2 is quite big. It's not as close. Usually when you have of course, the Supreme Court is always sitting in odd numbers. If you had 9 and it was 4-5, you could say review could work, right? If it was 7, it was 4-3, you would say, but 5-2 is not unanimous, but it is big enough, right? 5-2 is big enough. So clearly, the panel thought that the 3 senior citizens had a case. So now, what happens next? The court has given the political parties 1 year to dismantle the delegate system and open up the system for all registered members to vote. And they asked the Electoral Commission to enforce the transition across all political party organizations. This is very, very significant. Happening 150 years after the Supreme Court was born. So whoever saw that coming. Now, let's turn our attention to reactions. We'll start with civil society because they have been following this very closely. And I'll speak to Kojo Asante of the CDD next.
In my line of work, a confident smile is everything. Kel Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kel Charcoal Toothpaste. Kel Charcoal Toothpaste. You're on a Kessie and in a kit one.
Samayo Kendini, a who be here, Semetra Sapapadia to a mammy manful. Kel Charcoal's natural ingredients, and a bomb is so buying, a man string, and a sense of Mama Hoto so a will beg you.
Kel Charcoal Toothpaste. Choose Kel Charcoal Toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kel, happy smile. This advert is FDA approved. Imagine a life where every moment flows effortlessly, where every choice brings you closer to the life you've always wanted. Give yourself more ways to receive joy. Have more time to party. With G Money, every moment flows seamlessly. Just pay and keep the good vibes going. instantly top up airtime or data so you never miss life's special moments, because your memories together should matter more. Give yourself more freedom to celebrate. Pay bills quickly and seamlessly so nothing disrupts your moments. Have more financial control. With G-Money, you can effortlessly manage bulk payments and keep your business running smoothly. Dial star 488 hash or download the app and explore the new G-Money today. G-Money. Give yourself more.
Why? What's wrong?
Introducing Ghana's leading pay-as-you-copy photocopier leasing company. Lease an A4, A3, heavy-duty or production machine and pay for only the copies made, or design your own payment plan. Simple and tietia. That's not all. Incredibly, toners, repairs, maintenance, follow-me printing, centralized tracking all come free of charge. Remember, financial prudence is the name of the game. Folks, forget about the expensive gimmicks and be smart. Join the hundreds of satisfied clients across all the 16 regions and every sector of the economy and save over 60% of your printing costs. Visit us at www.valixlease.com or call 0244-644048. Be prudent and lease a copier. Terms and conditions apply. Valix Lease is a wholly owned Ghanaian company. Valix Lease, affordable document management solutions.
Welcome back. So tonight we are taking you to the law court. The Supreme Court has by majority decision ruled in favor of I call them the big three now, Professor Kwabena Frimpong Boateng, Dr. Nyaho Tamaklo, and Dr. Christian Amakunuyama. So now let's speak to one of the key people on both cases. So Kojo Asante obviously is one of the key figures at CDD, and I'm sure they are very interested in this matter. Indeed, in the OSP matter, civil society joined as an amicus to help the court, and therefore they are very happy, I'm sure, with aspects of the OSP judgment as well. Let's start with the issue of political parties and the way they conduct their elections. Kojo, thanks for joining us. I always ask this question. Your role at CDD, you are the director of advocacy, policy
engagement
and
partnerships.
Wonderful.
My role keeps changing.
Yes. How important was this case that these three, I call them senior citizens, Frimpong Boateng, Nyaho Tamaklo, and Christian Amakunuyama, how important was this case for our democracy, and how closely was CDD and other society groups monitoring it?
Thank you very much. I think this is a landmark decision. I mean, when I was sitting in court, when the judges gave the judgment, and first it surprised me. I wasn't sure where the court was going to go on this matter, but the excerpts that the Chief Justice read really suggested that they have reflected deeply on this matter. And it is a landmark decision, and the timing is I think impeccable, because as you know, we are in the throes of the constitutional review process, where this matter, in terms of the internal democracy of parties, the monetization of parties, politics, has been a huge issue that the CRC has proposed some reforms around it. So this is almost like to even push us quicker to respond to those issues even before we get into the insights of the constitutional reform. So I mean, the timing for me, I think, is impeccable. But I walked away from the court today feeling elated, by the bravery of the courts. They think the time is now for us to reform and just basically trigger the process.
The AG was one of those who were respondents, right? So if you look at the defendants, MPP was number one, NDC number two, CPP number three, EC number four, Attorney General number five. It appears the position of the AG in supporting the plaintiffs was crucial here. I mean, I want you to put on your legal hat and break that down for me. How important was it for the AG? I'm not sure if the NDC as a party necessarily supported what the AG did, but we know that the AG in his response agreed with the plaintiffs. How crucial was that?
It's a yes or no. I mean, it's certainly the representative of the government and his position can weigh heavily in a constitutional case like this. But as you know, when we come to the OSP, it went the other way. So it is not guaranteed. But I think that the fact that almost all the parties were on one side, and it was only the MPP that was on the other side, probably also made the case stronger for the applicants. Because if you had like a tussle where at least the two major parties may have been on one side or the other, and the smaller parties may also be split, you would think that it would create some tension. But when we do receive the full judgment, we'll really get into the reasoning. But I think that it was probably more because almost all the parties were agreed on one side for direct elections, and it was only the MPP that was not. And I think their main case was around the cost of expanding the election to everybody. And the court seems to have weighed that and thought that still affirming the principle of direct elections was better for Ghana, and we should find a way to deal with the cost issue.
So what was wrong with the status quo ante?
So I think the delegate system was producing many governance challenges. I think for most people, first of all, the fact that it sort of created a select few of people to select their leaders through the party system, and that excluded many people in the decision making as to who leads the party for parliament and then presidential. And then it created the whole monetization problem, where people were being induced to vote one way or the other, and the corruption that it generated around that. So there's been a lot of complaints, even from the party people themselves, about the system, the unfairness of it, the exclusionary nature of it, the fact that it created integrity issues for those who then eventually emerge out of that process, and the bedding of the cost that they carried into the state management. So there are many problems with it, and it was one of the issues that was featured in the constitutional review process, where the specific proposals were made to actually go to direct elections. So it has been an ongoing process for a long time. And the question for the court was that in our scheme of electing leaders, was the delegate system in contravention of what we have agreed within the Constitution? Because if you look at Article 55, it says the internal processes are supposed to mimic our constitutional order and culture. And if you look at elected leaders for public elections, they are all by direct elections. So the processes for internal party process elections being on delegate system, then appeared inconsistent with that ethos that has been established in the Constitution. So I think that's what the court affirmed that. But as I said, it was not just affirming the principle of direct elections. It was also, how do we deal with all the problems that we are facing around monetization, around the rising cost of elections, and around the corruption that has come to engulf that process.
So political participation is very important, and we are all happy that all ordinary members of the parties can take part in choosing their flag bearer and also the parliamentary candidate as it pertains to their constituencies. But there is a cost to registering members. Indeed, the two leading parties argue that in terms of sympathizers, they have over 4 million. Of course, there is a sympathizer and a member. That means that the pool of people who will be eligible to choose a flag bearer becomes very big. So if, for example, one of the parties decides that all sympathizers who want to become members should register, you're having a national type level election to just choose a flag bearer. I mean, the cost of that could be much, much more than using just 200,000 delegates, wouldn't it?
Yes, I think there's a cost element, and this is a basic problem with our democracy, which I think that we have not put our mind to fixing it. There are many, many other models in which you can try and fix this problem. The reason why, for example, the CRC proposes a democracy fund. So first of all, the state must invest in this democracy if it is going to keep the democracy clean, is going to keep it fit for purpose. Because what happens internally is, I mean, you can say garbage in, garbage out, right? If you don't protect the internal processes, you are not going to be able to get the kind of outcomes you have at the public election. So, for example, if the Electoral Commission supervises elections for internal processes, it cannot be the cost of the parties.
Okay.
It has to be absorbed by the state. We need to be able to make those kinds of investments, right? The issue of registration. Most of the people who normally would be members in good standing in political parties are already registered voters. I think in some cases, they even check your national ID in order for you to register as a political party. There are processes now that should allow for, working with the EC to be able to produce that register for you, right, and vetted and so on and so forth. So what I feel is that yes, this has come, and parties may feel overwhelmed and feel that there's so much to do if we're going to now expand the electoral college. But I think what then should happen is it's not just a question for the parties. This democracy is for all of us. So we should all fashion out a system that is credible, that works for everyone. And I think we can do it. And we need to invest in it. For me, I think this idea that somehow the parties should go and do their own thing and then come and stand for public elections is not right. And we know the challenges that come with that. So I think that there's a lot of things that we can absorb the cost. Also, the campaigning, for instance. So once you get into the vote buy, then the cost really is rising. There has to be ways in which we cap these kinds of expenditures. At the end, it's competition. If one person is doing it and is not in check, the other person will also do it. So there's a way in which we can rein in the cost issue. But I think it's fair that when you are building a democracy, you build it from bottom up. And that people who subscribe to parties' ideology and activities are able to participate fairly in the activities of the party. At the moment, a lot of people feel very excluded and just feel alienated from the party. And that is also affecting the commitment to democracy, which is a problem now for even the youth.
Thank you. Let's deal with the OSP matter now before I speak to the politicians about the Supreme Court, the voting matter. So we know that Noah Damate had gone to Supreme Court to essentially challenge the constitutionality of the setting up of the OSP or the OSP office. Civil society took a keen interest in this, particularly when the SP was not allowed to join in its initial attempt. Why did civil society think this was an important case? Why did you join the case? And then how do you welcome the affirmation of the constitutionality of the office?
Yeah, so we were motivated to join the case, particularly when the AG filed to, and in his response as a defendant, filed to basically agree with the applicant, because we felt that the court was not being given an alternative reasoning for why we thought the constitutionality of the OSP has to be, upheld. So we felt that we needed to give the court arguments to the contrary to what the applicant was doing. So basically, we ended up being like the the defendants, because we were the only people presenting a different case. And I think the court affirmed the authority of the AG, currently under Article 88, as having exclusive jurisdiction over prosecutions, but also that he has the ability to delegate that power through law, and that has been done in the OSP Act and its regulations through authorization, and so the current OSP law was consistent with the constitutional provisions, and then make consequential orders as to the effect of actions that have been taken so far in prosecutions, freezing orders, and other things, and all of that. So for us, this is what we believed, because we thought that that's exactly what has been done, and was done through law. And the OSP was not the only case. There are many provisions and statutes that give the same kind of authorization, whether it's for the narcotics, health sector, SNIT, revenue, Ghana Revenue Authority, all of that. So we didn't see why the OSP's statute was being singled out for this particular challenge.
So this should give the OSP some relief to proceed, but some feel like the ruling that the AG, by virtue of Article 88, has the power to discontinue a prosecution undertaken by the OSP. They felt that sort of undermines the power of the SP. Is that really a new thing, or has that always been there? And did they just affirm it? And does that affect the situation in any way?
The way I read it is this: just like the court said, it affirmed the jurisdiction of the AG for prosecutions, and also the fact that it can delegate. The current OSP law also gives the OSP the power of nolle prosequi. So if the court is affirming the constitutionality of the statute, that with all the terms within which the OSP can operate, I think that affirmation also covers the nolle prosequi. What the court have said is that if at any point the AG feels that it wants to take his power back, it wants to amend the terms, the same way in which it set out those terms, it can go back and do that. And that, in my reading, means you can go back and amend the law, you can go back and repeal the law, and basically take your power back. So I don't see a situation where another prosecutor will be used, in the way in which people are like, if the AG was itself prosecuting, because that would be a bit odd. If you want to trigger that process, I think that then you have to change the terms within which you are asking the OSP to operate, right? And then the court was also very careful to make the point that the nolle prosequi is a discretionary power, and the discretionary powers under Article 296, are not supposed to be carried out in any capricious or arbitrary way. So it imposes a certain obligation to set out parameters as to how you are going to exercise these kinds of things. So I think I don't envisage a situation where the AG, maybe through its supervisory activities, would be entering nolle prosequi to stop. Then of course that would also invoke a certain political cost, because people will be asking, why are you withdrawing cases that were being done by the OSP? So I think that what this should all tell us is that all these things have to be done in accordance with law and done properly, so that it doesn't cause any disruptions to the functions of these institutions that the AG has given power to.
Finally, there are some elements within the government who may not like the fact that the OSP exists, and so they may want to use another route. And I think you hinted that it's possible to repeal the law. But I think when you listen to the president, he's been saying that the office must be given time to function. So it appears that the Supreme Court judgment would sort of solidify the president's position that if there are even any attempts from any quarters in government to eviscerate the office, it will not get presidential support from the way I read his commentary, correct?
And it shouldn't also get the support of any parliamentarian, because I think the people are also very clear that on this particular issue of the having an independent office that prosecutes corruption of politically exposed persons, that they don't believe that an attorney general that is sitting in cabinet with his colleagues and basically an appointee of the government is one that can do that independently. And we've had 30 years of that exercise. We can all come to a judgment on that. So I think we've gone past. For me, this matter was resolved from APRM time in 2004, and we've had more than many years to reflect on this, and the people are quite clear. So I see the long-term resolution of this, that we look at our constitution and make sure that we elevate the whole issue of anti-corruption and an independent public prosecutor, or a prosecutor who is dealing with anti-corruption into the constitution, so that it's protected.
Thank you, Kojo Asante, who's the Director of Policy and at CDD. This is the point of view. Tonight is a legal night. Two big judgments in the Supreme Court. The matter of the delegate system, choosing our presidential and parliamentary candidates. Supreme Court says it's unconstitutional. Open it up. We also spoke briefly about OSP. When I come back, I'll speak to the politician. I'll speak to Gary Nimako, who's the Director of Legal for the MPP, on their position, and we'll take it up from there. Stay with us.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach, you don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights and discover spaces crafted for comfort, style, and everyday living. And just when it feels right, you will know. Because this isn't just about finding a house, it's about stepping into a better way of living. Eden Heights, the height of modern living. Book a private viewing today.
When malaria shows up, it doesn't knock. It just takes over.
No. This fever is too much.
When malaria comes, respond with Mala2. Fight malaria with Mala2 tablets or syrup from Ernest Chemists. Test for malaria first before taking Mala2. If symptoms persist for more than 48 hours, see a doctor. This advert is FDA approved.
In today's fast-paced African business landscape, human resources is no longer just a support function. It's the strategic heartbeat of your organization. Are you prepared to lead that change and redefine your professional impact? Welcome to the HR Connect Conference 2026. This year, we are diving deep into our professional theme, from certification to competence. Why elevating HR is critical for business growth and competitive advantage in Africa. We are profoundly honored to host our guest of honor, His Majesty the Gamanche, King Takitaiko Churu II, alongside our distinguished guest speaker, Honorable Haruna Pelpo. Over 2 transformative days at the prestigious Labadi Beach Hotel, you will go far beyond traditional theory. We have curated an immersive experience designed to challenge your thinking and sharpen your edge. You will have the opportunity to participate in our expert-led masterclass sessions, including personal branding and mastery, the CDAT compensation and benefits masterclass, our critical labor law masterclass, and the forward-looking SHRP future of work masterclass. Beyond the masterclasses, you will gain rare, high-level perspectives during our exclusive C-suite sessions, engage in intimate fireside chats, and participate in our interactive table talk sessions focusing on HR mentorship mastery and the latest in HR tech. Proudly partnered by CDAT Consult and SHRP, this is the premier gathering for HR professionals ready to shape the future of our industry. Mark your calendars for July 30th and 31st, 2026, starting 9 a.m. sharp each day. Elevate your practice, drive your business. Join us at the HR Connect Conference 2026. We look forward to connecting with you there.
Welcome back. Tonight we're delving into the 2 big cases. Indeed, Kojo Asante describes this as a landmark case. The declaration that the delegate system is unconstitutional, and Dr. Christina Makuniama, Dr. Nyahota Maklo, Professor Frimpong Boateng, 3 senior citizens taking the matter to court, represented by Oliver Baka Vomawo. Interesting, the defendants were MPP, NDC, CPP, EC, and AG. It's not very often that you see NDC and MPP on the same side. So this was quite interesting. Now, Gary Nimako is the Director of Legal Affairs of the MPP. From what we've heard, the NDC and the CPP and the Attorney General, even though they were defendants or respondents, agreed with the plaintiffs. But we do not, the MPP, we do not think so. So, Gary, thanks for joining us. The MPP did not agree, even though you were a defendant and your other defendants sort of agreed. You didn't agree with what the plaintiffs were calling for, did you?
Good evening to your cherished listeners. Yes, we did not agree that the delegate system we've been practicing for all these years is unconstitutional. It's not democratic. Let me be quick to point out that the Supreme Court did not say that the delegate system is unconstitutional. I sat in the courtroom, I listened to them. They didn't say that. What they said was that there was corruption in the delegate system, and so therefore they think they ought to open it up for others to come in. Others meaning that all registered card-bearing members who are in good standing should be allowed to take part in the voting process. Now, because the full judgment is not out, it's not out, it is very difficult for me to really make a determination as to why the court ruled in the way it did. Because you will need to, first of all, make a determination that the delegate system is not constitutional, first of all, or is not in accord with democratic principles. Then you can now depart. They didn't say that. The court didn't say that.
Let me tidy up what I said. I agree that they didn't say that the delegate system. What the plaintiffs were looking for, and this is point 4, a declaration that the delegate-based electoral college system, which confines or restricts voting to specific executives, office holders, and delegates to the exclusion of or material disenfranchisement of members in good standing of the party, contravenes the preambles and articles 117, 33, 535, 6D, and 42 and 55 of the Constitution, and is therefore unconstitutional, null, void, and of effect. So it's not the fact that the system cannot be unconstitutional, because we need delegates or different levels of executives. But I think we need to take it together that the delegates-based electoral college system, which confines or restricts voting to only these persons, to the exclusion of ordinary members. So we need to take it together, sir. Does that satisfy you?
Okay, so the difficulty that I have with this entire matter is that even in America, we have the system electing the president. Not every American citizen takes part in the process of direct voting to elect the president. It goes what they call electoral college system. That is democratic. If you come to Ghana, we follow the same thing for all these years. It is democratic. If you really go to parliament, not all members of our country or citizens of our country will sit in parliament. All right, we elect members of parliament to go and sit in parliament. It is democratic. If you go to council of states, it is the same system. It is true election. It is democratic. Now, that's why I'm saying that we are waiting to see what the reasoning actually is. Because at this stage, it's so difficult to make the analysis.
No problem.
Because so you have to make a determination that what has been existing all these years is not democratic. You cannot depart. But when they came, they just came and said, well, they want to read excerpts of them. And then what they read to us in court was that corruption was rife in the delegate system, so they want to open it up to make it more democratic and all that, without telling them the reason or the rationale or the ratio.
No problem.
So difficult for us
but
to make
absent the full judgment and the ratio, we still understand the consequence of the determination, because they also gave an order that within a year, all the political parties must make arrangements to include all registered members in voting, which suggests that your parliamentary primaries that are ahead of you will necessarily have to involve all MPP members. At least we can establish that, correct?
You see why I was laughing when I left the courtroom? You know, political parties, first of all, they are voluntary organizations. They are organizations that are being run by their own internal constitution. That is one. Two, elections, as they stand, entails cost. Now, with the system that we run now, the delegate system that we run now, the cost is borne by the political party itself, or by sponsors and donors, and the candidates contesting for the elections. Now, if you say that now all card-bearing members in good standing should take part of the processes, and the political party is unable to raise money to organize the said elections, how is the order of the court going to be enforced? A court does not make orders in vain. A court orders are meant to be enforced. You understand? Elections is about cost. So I ask the question, who is going to fund the elections? Is it the state that is going to fund the elections? Is it a political party that is going to fund the elections? Is it the that are going to fund the elections? Who will bear the cost of funding the elections? That is the question I've been asking. I haven't gotten the answer to that question.
Does it matter that the EC was included in the suit and were also ordered to ensure that they enforce, I'm looking for a better word, the order, in the sense that elections are managed by the EC? So that
elections are managed by the Electoral Commission.
Yes.
But the elections are not funded by the Electoral Commission. It is the political parties, for instance, the MPP, we pay the elections ourselves. We fund the elections ourselves. We pay for the Electoral Commission. They bring budget to the party, and the party pays the budget to the EC. So, for instance, in the election, let's say polling station agents, the EC will bring a budget that in an election of this nature for the whole country, you are going to pay, let's say, X amount of money. This is the budget. And the political party finds money to pay the Electoral Commission. So they come and supervise the elections. Polling station, electoral area constituency. It is paid by the political party itself. So, in an instance that an order is made that every card-bearing member of the party should be allowed to participate in the process. It means that the electoral college will have been enhanced more than 10 times or 4. If, for instance, now those who are taking part are let's say 2 million.
Mm-hmm.
If you let all members take part in the elections, it means you are looking at about 10 million, 4 million, 5 million, depending on the numbers you're able to register.
Mm-hmm.
And the question I ask, who will fund the cost of these elections? Is it a political party? Is it the electoral commission? Is it a state for consolidated fund? Who will fund this election? That's the question.
That's a very good question. I asked Kojo Asante, who is from CDD and who supports the new position, and he suggests that they in civil society are mooting for some fund to be set up by the state to support political parties in elections. Indeed, he says this coincides with constitutional review. So he did say that the civil society groups are mooting, I don't know what they call the political parties fund or elections fund, but a fund that will support this. But I just wanted to ask another point. The MPP itself has been expanding the electoral college gradually, because I know that the primaries that elected Akufo-Addo for 2016 was much, much, much bigger than the primaries that chose him for 2012. And indeed, at the time, NPP said they were organizing the largest internal election, if I'm not mistaken, because they had expanded from a very few delegate group, what was happening in Legon in 2007, to a full, almost a disenfranchised regional-based election, I think constituency-based or something. So if the parties themselves are on that trajectory, maybe the issue is just saying hurry up, because eventually we're going to get there.
If you recollect, as you are rightly pointing out, we have been moving at the pace that we've started. You will have seen that much more bigger electoral college will be seen. If not for a better word, even all card-bearing members in good standing will have been voting. And the internal system will have been built up, except who are actual party members, who are not actual party members. Don't forget, NDC itself did this thing some time before. And then they claim that there were people who are not members of their party who came into their party fold, they came and changed the leadership for them.
All right, Gary, these are early days. So you heard Gary Nimako clearly disagreeing with the court, waiting for the full judgment. We'll have it next week. But MPP does not seem to agree. The NDC, we are told, and from interviews we've done, even in the program before this, clearly they think this is good and they support it. Their position is similar in a way to the CDD position. Earlier on, we spoke to Kojo Asante and also took you through the key elements of this very, very important judgment for our democracy. So thanks for watching tonight's edition of The Point of View. My name is Bernard Avile. We'll see you next time. Bye-bye.
This one. Thailand.
Chai!